Okay, let's unpack this. Today we're doing a deep dive into a really pivotal stage of the U.S. patent process.
Yes, specifically appealing a rejected patent application.
Right. Within the USPTO, directly before the Patent Trial and Appeal Board, the PTA,
hmm
it's that moment, when an applicant says, hold on, I don't agree with the examiner, and decides to, well, take it upstairs.
And to guide us, we're basically looking at the rule book, key parts of the Manual of Patent Examining Procedure, the MPT. Chapter 1200 is the big one here.
It's our map, basically.
Exactly, for navigating these ex parte appeals.
So our mission for this deep dive, we want to cut through all that dense legal language, make sense of what can be a pretty intimidating process,
Yeah, highlight the crucial steps, the deadlines you absolutely cannot miss.
and maybe uncover some strategic points, some potential pitfalls too. It's really about understanding what happens, why, and how you might navigate it if your claims get rejected.
That's it. We're going to trace the whole journey, starting the appeal, building your case in that critical appeal brief, what the examiner does next.
Even things like oral hearings and how appeals end. It's quite formal, isn't it? Like a court case inside the patent office.
It is. It's based on statute 35 U.S.C. 134, specifically for resolving these disagreements over patentability, usually things like prior art rejections.
And just a quick clarification, we're mainly talking ex parte appeals, right? Applicant versus the office.
Correct. Not really digging into interpart stuff, which usually involves reexaminations. And most of what we're discussing applies to appeals under the newer rules, Post-America Invents Act, so roughly late 2012 onwards.
Okay, so picture this. You've got that final rejection. You're convinced the examiners missed something crucial. What's the very, very first thing you have to do to signal you're fighting back?
That first move is filing the notice of appeal. Simple as that. It's your formal heads up to the USPTO. I intend to challenge this decision before the PTA.
Okay, filing the notice. Sounds simple. Any tricky bits.
Surprisingly, yeah. The MPP says the notice document itself doesn't strictly need your signature. Yeah, and here's the catch. If you file other papers with it, like the form to pay the appeal fee, that definitely needs a signature.
Okay. So if you forget to sign the fee payment form,
Then the fee isn't paid properly, and your notice of appeal could be considered defective, invalid, basically.
got it. So the notice is easy, but don't forget to sign the check, metaphorically speaking.
Right.
What else makes that notice defective?
Well, it has to actually be a proper response, meaning you're appealing claims that were actually rejected, usually twice.
Makes sense.
It has to be filed on time, within the deadline from the final rejection, and like we said, the fee has to be paid on time. Miss any of those, and it's defective.
And who catches these initial mistakes?
That's usually the Patent Appeal Center. They do the first check. If they spot something wrong, they'll typically let the applicant know, give them a chance to fix it.
All right, so notice filed, fee paid, it's all good. Now, before you dive into writing that huge appeal brief, are there options, things to consider in that gap?
There are. Interesting one is a pilot program called the Pre-Appeal Brief Review.
Pre-appeal brief review. Okay, what's that?
You can ask for a panel. It includes a supervisor and the examiner who rejected your claims to take a quick look at your arguments before you write the full brief.
Huh. Why would you do that?
Well, the hope is they might see your point, maybe realize the examiner missed something, and decide to reopen prosecution right then and there. Avoid the whole brief writing process.
That sounds pretty good, but I bet there are limitations.
Oh, absolutely. Big ones. You, the applicant, you're not allowed to be there. No meetings, no interviews during this review.
So you just send your points in and cross your fingers.
Pretty much. You submit your request, your arguments, and you wait. Now, filing this request might push back your deadline for the main appeal brief, but it's a bit of a gamble. The panel could just agree with the examiner, and then you're back where you started, maybe with less time.
Right. Speaking of interviews, what's the deal after you file the notice of appeal? Can you still talk to the examiner?
Generally, yes, but only before you file the appeal brief. You usually get one interview after the final rejection, but that window typically closes once the brief is filed.
So that pre-brief interview is likely your last chance for a direct chat.
Usually, yes. The MPP is pretty strict. Interviews after the brief are rare. Exceptions might be like if you're just canceling claims to get the allowed ones issued, or maybe if the examiner has a sudden change of heart, but don't count on it.
What if, after filing the notice but before the brief, you realize, oops, I need to tweak a claim, or I found some great new evidence? Can you add things then?
You might, but it's tough. Amendments or evidence filed in that specific window after notice before a brief generally only get in if they cancel claims, fix formalities, put claims in better shape for appeal, or if you show really good and sufficient reasons why you couldn't present them earlier.
Good and sufficient reasons. Sounds like a high bar.
It usually is. And remember, stuff filed before the notice, but after final rejection is handled under different, slightly more lenient rules. But once that notice is in, the door starts closing fast on new stuff.
Okay, that makes sense. The window shrinks. Which brings us then to the main event, the appeal brief. This sounds like the core of your case for the board.
It absolutely is. It's non-negotiable. If you file a notice, you must follow up with a compliant brief on time, or the appeal just gets dismissed. Game over.
And its purpose is to tell the board exactly why the examiner got it wrong.
Precisely. And here's a huge point. You have to argue against every single ground of rejection the examiner raised for the claims you're appealing.
Every single one. What if you miss one, maybe for a dependent claim you didn't care much about?
Big mistake. The MPP is clear, fail to argue a ground, and you've waived your right to challenge it. The board can then just summarily sustain that rejection, basically agree with the examiner without digging into it.
Ouch. So that claim is just gone.
Pretty much, for the purposes of the appeal. And it could even hurt your chances if you try to appeal further to the courts later on that specific issue. It's a critical error to avoid.
Wow. Okay, so the brief needs to be comprehensive. What's the required structure? What has to be in there?
There's a specific order, specific headings. First, real party in interest.
Why is that needed?
So the board judges can check for conflicts of interest. You have to list the assignee, any parent companies if it's a joint venture, basically anyone with a real stake, unless it's truly just the inventors.
Okay, transparency for conflicts. Got it. What's next?
Related cases. You need to tell them about any other relevant appeals, court cases, interference proceedings, anything involving you or the assignee that might bear on this case. Again, it's about full disclosure.
Right. Then we get to the invention itself.
Yes, the summary of claims subject matter. This is an argument, just a clear, concise explanation of what each rejected independent claim covers, and any dependent claims you're arguing separately. You point back to your specification, your drawings.
Okay. And there's a special rule for means plus function claims.
Absolutely. For those 112 claims, you must pinpoint the specific structure, material, or acts in your specification that correspond to the means for or step for language. You need page and line numbers. It tells the board exactly what you think those terms mean in your context.
Very specific. And then the argument section, the real meat of it.
Exactly. This is where you make your case. You need a separate heading for each ground of rejection you're fighting. Under that heading, identify the claims, the statute, like 102, 103, and the prior art reference.
What if multiple claims are rejected for the exact same reason? Can you group them?
You can, yes. To be efficient, you can say claims 1 through 5 stand or fall together on this argument. But another crucial point, if you group them, you must be explicit about it.
And if you don't argue them separately later?
Then you've waived the right to have the board consider them individually. The MPP says the board can just pick one claim from your group, decide the rejection based on that claim, and apply that decision to the entire group.
Ooh, so grouping is efficient, but risky if there are nuances between the claims.
Exactly. You bundle them, they get decided together. So choose your groups wisely. And your arguments for each rejection need to explain why the examiner erred, citing statutes, rules, case law, evidence from the record, the whole 9 yards.
So build a strong case based on the existing record.
Oh.
What definitely cannot go into the brief.
Super important. No new amendments, no new affidavits or declarations, no evidence that wasn't already admitted by the examiner.
So if the examiner refused to enter something earlier?
You can't sneak it into the brief. The board reviews the examiner's decision based on the record as it stood when the decision was made. Challenging the refusal to enter something, that's done via petition to the director, a totally separate process, not in the appeal brief.
Got it. Appeal brief is for arguing the merits based on what's already in. Is there any leeway for people filing without an attorney, pro se applicants?
Yes, there is. For pro se folks, the rules say they only need to substantially comply with the requirements for the real party, related cases, argument, and the claims appendix sections. A bit more flexibility there.
In the claims appendix?
What's that? Just a clean, double-spaced copy of all the claims that are actually part of the appeal helps the board have them handy. It's also a good idea, though maybe not strictly required anymore in the appendix itself, to include copies of key evidence you rely on, like declarations. Just makes it easier for the board.
Makes sense. Okay, so the applicant puts together this monster brief, argues every point, follows the structure. Now the ball's back in the examiner's court. What's their response?
Well, after getting the brief, the examiner might actually be persuaded and allow the application,
Oh,
or they might find a reason to reopen prosecution. Or, more commonly, if they're sticking to their guns, they draft the examiner's answer.
which is basically their rebuttal to your brief.
Exactly. It's the examiner's chance to respond to your arguments and explain why they believe the rejections should be sustained by the board. The answer has to state all the grounds of rejection they're still maintaining.
Do they have to maintain everything, even if the applicant didn't argue one point?
Generally, yes. Unless the applicant clearly overcame the rejection, the examiner usually keeps all pending rejections active in the answer. Although remember, if the applicant didn't argue it, the board might summarily affirm it anyway.
Right. Defending the original stance.
Mm-hmm.
But here's where it can get really interesting, right? The possibility of a new ground of rejection appearing in the answer.
Yes, this is a major fork in the road. If the examiner's answer includes a rejection that is specifically designated as a new ground, it triggers a very specific set of options and a strict deadline for the applicant.
Okay, what's the deadline and what are the choices?
You get 2 months from the mailing date of the answer containing that new ground, and you must choose one of two paths. Fail to choose, and the appeal gets dismissed for the claims facing the new ground.
2 months. Path 1.
Path 1. Reopen prosecution. You file a reply that meets the standard for responding to a non-final office action. Critically, this reply can include amendments or new evidence, but only if they're aimed at overcoming that new ground. Choosing this path means you withdraw the appeal for those claims.
So you pause the appeal, go back to the examiner, and try to fix the new problem, maybe with new claims or evidence.
Precisely. You're essentially saying, okay, let's deal with this new issue back in regular examination.
And path 2.
Path 2. Maintain the appeal. You do this by filing a reply brief. This brief cannot contain new amendments or evidence, it's argument only, and it must directly address the new ground of rejection raised by the examiner.
So stay on the appeal track, but fight the new rejection purely with arguments in the reply brief.
That's the choice. Back to prosecution with potential new evidence, or stay on appeal with arguments only. And if you miss that 2-month deadline to pick one, dismissal sua sponte automatically, but only for the claims subject to the new ground. If all your appealed claims got hit with new grounds, then the whole appeal goes away.
Wow, okay, so that 2-month clock for a designated new ground is serious. What if you read the answer and think, hey, this rejection feels new, but the examiner didn't label it as a new ground?
Different situation. You cannot just argue this is an improper new ground in your reply brief. The only way to challenge the examiner's failure to designate it as new is by filing a petition to the director.
A petition. When?
Within 2 months of the answer's mailing date. And crucially, before you file your reply brief, filing the reply brief first waives your right to petition on that issue.
And does filing the petition stop the clock for the reply brief?
No, it doesn't. So you might have to prepare the reply brief anyway, even while the petition is pending. It's procedurally tricky.
Definitely sounds like timing and procedure are absolutely critical here. What if the case gets sent back to the examiner by the board? A remand, you called it?
Right, a remand. If the board remands and the examiner then issues a substitute examiner's answer, your options depend on why it was remanded.
How so?
If the remand was for the examiner to further consider a rejection, maybe the board had questions about it, then when the examiner issues the substitute answer, you get those same two choices again. Reopen prosecution with a full reply, maybe amendments evidence, or maintain appeal with just a reply brief. Same 2-month deadline.
Okay, but what if the remand was for something else?
Right. If the remand was for a different reason, like maybe to consider an information disclosure statement, IDS, that wasn't looked at, or some other evidence, then after the substitute answer comes out, you only get the option to file a reply brief. You don't get the option to reopen prosecution in that scenario.
Huh. So the reason for the remand dictates your response options to the substitute answer. That's subtle. Okay, let's zoom out a bit. When the board is actually making its decision, what are they looking at? What's the official record?
That's fundamental. They decide based on the record. And the record is basically everything that was properly entered into the official file, usually the electronic image file wrapper these days.
That word entered seems important.
Critically important. The MPEP explicitly says the record excludes things like amendments, affidavits, other papers that were filed but not entered by the examiner.
So the board doesn't review the examiner's decision not to enter something.
Correct. That refusal to enter is something you'd challenge via petition, not appeal. The board looks at the rejections based on the information the examiner did consider and formally made part of the record. If it wasn't entered, as far as the board is concerned for the appeal, it doesn't exist.
Are there any weird exceptions? Like, what about dictionary definitions? People cite those all the time.
Good question. Yes, dictionaries get special treatment. They are not considered evidence for appeal purposes.
Why is that helpful?
It means both you and the examiner can cite dictionary definitions in your briefs and answers to clarify terms without it automatically being treated as introducing new evidence, which could cause procedural problems like triggering a new ground. The idea is that courts and tribunals can consult dictionaries anytime to understand ordinary meanings.
That's a useful, practical point. Okay, we've covered the paper trail, the written arguments. What about actually talking to the judges? Is an oral hearing mandatory?
Not at all. It's completely optional. The MPEP emphasizes that appeals decided just on the briefs get the exact same level of consideration. You should really only ask for one if you think verbally explaining things, maybe complex tech or tangled prior art, will genuinely help the judges understand your case better.
Okay. If you decide you do want one, how do you request it?
You need to file a separate paper, clearly titled Request for Oral Hearing, and pay the fee. And timing matters again. You have to file it within 2 months from the examiner's answer mailing date, or the date you file your reply brief, whichever is earlier. Get it in before jurisdiction fully shifts to the board.
What happens at the hearing itself? Who talks first?
The applicant, usually goes first. You typically get about 20 minutes. You can save some of that for rebuttal after the examiner speaks.
And the examiner gets time, too.
Yes, they usually get about 15 minutes to present the office's side.
What can you actually talk about? Can you bring up that killer argument you just thought of?
Yep.
Or show them new data?
Almost certainly not. The rules are very strict here. You can only rely on evidence that's already in the record and arguments that were already made in your appeal brief or reply brief. No new arguments, no new evidence.
So stick to the script, basically. The script being your briefs.
Pretty much. There is one very narrow exception. You might be allowed to raise a new argument at the hearing, but only if you show good cause, and the argument is based on a very recent, relevant decision from the board or a federal court that came out after your briefs were filed.
Ah, okay. Only for brand new, relevant case law. What about visual aids, like PowerPoint slides?
You can use demonstrative exhibits, like slides or charts, but they are not evidence themselves, just aids. You have to submit them to the board beforehand, usually 10 days prior. And crucially, they can only contain information that's already in the official record.
And you have to label them clearly.
Yes, demonstrative exhibit, not evidence. And you bring your own laptop if you're doing a presentation.
Can anyone just walk in and watch these hearings?
It depends. For appeals on reexaminations, reissues, and applications that have already been published, yes, they're generally open to the public. But for unpublished applications, no, the hearing is private.
What if you request a hearing, pay the fee, and then the board decides they don't need it?
They can do that.
Yeah.
If they review the case and feel they can decide it based on the briefs alone, maybe they're already leaning your way or think a remand is needed, they can cancel the hearing. They'll let you know.
And what if you don't show up after requesting one?
Then they decide the case on the briefs, and you don't get your hearing feedback. So only request it if you mean it, and make sure you confirm and attend if it's granted.
Makes sense. Okay, we've gone through the whole process, potentially up to a hearing. How does an appeal actually end? Especially if it doesn't go all the way to a final board decision.
Well, it can end through withdrawal by the applicant or dismissal by the office. You, the applicant, can decide to withdraw the appeal anytime.
What happens then?
Depends when you withdraw. If it's before the board has officially taken jurisdiction for the decision, the case usually just goes back to the examiner. If it's after the board has it, the board handles the formal dismissal.
What if you change your mind and want to go back to arguing with the examiner, maybe with new amendments? Can you do that after starting an appeal?
Yes, for most applications filed since the mid-90s, you can file a request for continued examination, an RCE.
Ah, the RCE. How does that affect the appeal?
Filing an RCE always treats the appeal as withdrawn, automatically. It's basically hitting reset on examination. To do it properly, you need the RCE fee and a submission, which is usually a response to the last office action, maybe with amendments.
Does the appeal brief count as a submission?
Generally, no, unless you specifically incorporate its arguments by reference in the RCE paperwork. Usually you need a separate response document.
So RCE is a strategic exit ramp from the appeal back to prosecution.
Exactly. But here's a critical warning. Just filing the RCE form withdraws the appeal even if you forget the fee or the submission.
Oh, wow. What happens then?
If you file the RCE form without the fee or a proper submission and you don't have any allowed claims, your application could be considered abandoned. So be careful with RCEs during an appeal. The MPP also suggests letting the board know quickly if you file an RCE or abandon the case, just so they don't waste time working on a decision.
Good tip. Besides withdrawal, you said appeals can also be dismissed sua sponte, automatically by the office. When does that happen?
Right, we touched on some of these. If your initial notice of appeal was bad untimely, missing the fee dismissal. If you fail to file your appeal brief on time dismissal.
Yeah, in the new ground situation.
Yes, if you fail to respond properly within that 2-month window to a designated new ground of rejection in an examiner's answer or in a substitute answer after certain remands dismissal, at least for the claims affected by that new ground.
What if you only want to appeal some of the rejected claims, not all?
You can do that. You'd file an amendment canceling the claims you're dropping from the appeal. The appeal just continues for the claims that remain.
And going back to the brief, if you don't argue certain claims properly.
Right. If you appealed a claim but then failed to argue against its rejection in the brief, or if you grouped claims improperly and didn't argue them individually, the board can treat that as a waiver. They can summarily sustain the rejection for those claims. It's like a dismissal for those specific claims due to lack of argument.
So even if you don't formally withdraw them, failing to argue properly in the brief can knock claims out of the appeal.
Absolutely. Your strategy in the brief, which claims to argue, how to group them, making sure every rejection is tackled, directly impacts what the board will actually decide on the merits.
So wrapping this all up, what's the big picture here? It sounds like appealing a patent rejection isn't just one step. It's, well, a whole complex sub-process within the USPTO.
Definitely. It's not a simple staircase. It's more like a very detailed legal roadmap. You've got strict rules for starting the appeal, very specific requirements for that crucial brief, and these critical decision points, like how to handle a new ground of rejection. Success really seems to depend on knowing the procedures, hitting the deadlines, and making smart strategic choices.
Yeah, and the rules seem quite rigid about what you can bring in and when. It feels like mistakes made early on could really limit your options later if you end up needing to appeal.
That's a great point. And given the complexity, it's worth remembering there are resources out there, like the PTBIZ Pro Bono program, which can help inventors who might not have the funds for full legal representation navigate this.
Which leads to maybe a final thought for you listening. How much does the groundwork you lay during the initial back and forth with the examiner, the arguments you make, the evidence you submit, then ultimately shape your chances and strategic flexibility if things go south and you find yourself heading towards an appeal? Something to really consider as you plan your overall patent strategy